Welcome to the latest in our webinar series. This one is on the new UK subsidy control regime. And obviously knowing about that will let you answer the question, what can public money be spent on and when? Just by way of introduction, you don't necessarily need the pictures because obviously you can see both of us, but I'm Charles Livingstone. I'm a partner in the Government Regulation and Competition team at Brodies, and joined today by Jamie Dunn, who's an associate in the team. Among other things, Jamie and I specialise in what we used to call state aid and will now have to get used to calling subsidy control. So what we're going to cover today, the main questions: how do the tests for subsidy control differ from state aid law, the record keeping and publication requirements under the new regime, how it all interacts with the Northern Ireland Protocol, and how subsidy control law will be monitored and enforced. But to kick things off, I'm going to hand over to Jamie, who's going to touch on the recent changes and the current position. Jamie.
Thanks, Charles. So, as you probably know, the EU Withdrawal Act did a lot of copy pasting of EU law into UK law when the UK left the EU right at the tail end of 2020. That's subject to the ability of Parliament and in some cases ministers to amend or repeal certain EU law as it was retained within the UK. And one of those areas of repeal or non-retention was EU state aid law. So what has happened to state aid law? It has been revoked by the regulations that you see on the screen there. Now that means that Article 7 of the TFEU no longer applies, standstill notification requirements no longer apply, Commission approval is no longer something that is applicable within the UK. That was, I've mentioned there, subject to a legal challenge. The challenge was withdrawn because of the bill while it's going through, but that essentially means that the legality of those regulations has never been tested. We're just proceeding on the basis that they are what they are, but that was something that did happen. So what takes the place of EU state aid law? If you go into the next slide, so what we've got now is the Trade and Cooperation Agreement between the EU and the UK, and its chapter on subsidy control. So the concepts that we have are very similar to EU state aid law, but the terminology is a little different. It has its own definition now of what is a subsidy, sets out the subsidy control principles, of which more later on in the presentation. It has its own concepts of services of public economic interest, a little bit like SGEI, if you remember that, allowances for aid in emergencies, and its own set of de minimis thresholds. So the de minimis threshold has risen significantly from where it was before. It was £200,000 over a 3-year period, and it's now £340,000 over a 3-year period. Now, because we're looking at new terminology and we're looking at new concepts in a new agreement, there is potential scope to reopen how these things are interpreted, and it will remain an open question how these different concepts are seen under the new UK-EU TCA compared to how they were under the EU treaties and state aid, but we'll find that out eventually. And there are, just mentioned there, new transparency requirements and related challenge rights, which again are key parts of the bill that we'll come on to in a little bit. So how does the TCA apply in UK law? Well, it imposes a requirement on the UK to have an effective system of subsidy control, a requirement on the EU as well. So the EU implements that in its state aid regime, and in the UK, pending any more specific regime, it's through the TCA provisions being given direct effect in the UK under the EU Future Relationship Act 2020. So we've just quoted the relevant parts of that there, section 29, which says that all existing domestic law has effect on and after this coming into force, as it requires to be modified for the purposes of implementing the Trade and Cooperation Agreement to the extent that it is necessary to do so to give effect to the UK's obligations under that. Now that section, subsection 2 there, is subject to the ability of the UK to replace that with a more specific regime than the TCA, and that is exactly what the Subsidy Control Bill intends to do. So the Subsidy Control Bill is there effectively to implement the UK's obligations under the TCA in a more specific UK bespoke way, and will therefore replace this, but this remains the law pending that.
Yep, so that's where things stand at the moment. We did a webinar on that earlier in the year. You can probably still find that on our YouTube channel if you want more on the TCA and the regime that applies right now. It should be easily findable, but if you can't find it, just get in touch. But for the purposes of this webinar, we will mention the TCA here and there, but we'll largely be focusing on the Subsidy Control Bill, so we'll move on to that. So there's a link there to the bill, again, easily findable, but when you get a copy of the slides, which you'll get with the link to the recording, you'll be able to click through to that. So that's been introduced in Parliament, hasn't yet been amended, so it's just as published. As Jamie said, it's a more detailed domestic regime. The TCA kind of deals in skeleton rules, and the bill really fleshes those out. There is also some gold plating, to use former EU term of art. So there is some additional provision made. It's not simply implementing the TCA and no more. There are other requirements and considerations that have been adopted into the bill, which you'll pick up as we go through. The bill sets out various principles and rules, and with some modifications, those generally apply to subsidies that are provided by means of devolved primary legislation, so including acts of the Scottish Parliament. UK Parliament legislation is covered by the bill in some narrow respects, so it can, for example, be voluntarily referred to the CMA, and Jamie will speak later about the CMA's role. But otherwise, UK Parliament legislation is not, or subsidy conferred by UK legislation is not going to be within the scope of the principles and rules set out in the bill, or subject to the remedies in the bill. And that is consistent with the TCA, which the rules there didn't apply to legislation in the UK Parliament either. But devolved legislation is within the scope of all of those things. So the first question, what is a subsidy? Obviously, we had a fairly well understood definition or principle of state aid. What was an aid under the old regime. We've changed the word, but have we really changed the substance? So the definition of subsidy is set out in clause 2 of the bill, and it is financial assistance which is given directly or indirectly from public resources by a public authority. And we're going to come back to all the coloured text, so I'm just going to skip over some of this, but you can see how it all fits together. And that includes by direct or contingent transfer of funds, so direct grants, or contingent being loans, guarantees. Sorry, contingent being guarantees, direct being grants and loans. The foregoing of revenue that is otherwise due to a public authority. So that's, again, that's consistent with the state aid regime. And potentially also the provision of goods or services, or the purchase of goods or services. Again, not a surprise there. Providing goods or services for undervalue, or buying something for overvalue was always potentially going to be a state aid under the old system. The assistance has to confer an economic advantage on one or more enterprises, has to be specific, meaning it benefits certain enterprises over others in relation to the production of goods or provision of services. That's the statutory language. And it has or could have an effect on competition or investment within the UK, or trade or investment between the UK and another country or territory. So the gold colouring there is appropriate, because that is one of the examples of gold plating. The TCA didn't require there to be any provision made for subsidies that affect competition or investment intra-UK, or indeed trade or investment between the UK and countries that are not in the EU. But the bill does not distinguish between those concepts. Probably will make it easier to manage, but it does mean that there will be subsidies that are caught by the bill that wouldn't have been caught by the TCA. So if we break down those aspects of the text, public resources by a public authority. So the TCA speaks of the resources of the parties there being the UK and the EU. The assumption is probably that that's equivalent to the state aid test of aid granted by a member state or through state resources, but there isn't really then any unpacking of the concept of public resources. Public authority is defined in clause 6, and it's defined as a person who exercises functions of a public nature, but other than the various legislatures. Now that is potentially a tricky definition, because the Human Rights Act contains essentially the same definition of a public authority, and that has been expanded to include private entities who provide functions of a public nature or public services, so care homes being the most obvious example. So the fact that the assistance has to come from public resources might avoid too much difficulty in terms of private bodies that nevertheless do quote unquote public things. But the definition, I think, probably could have been a little bit neater. And we'll see how that plays out. It'll be marginal cases where it's going to be an issue, but I think there will be cases about that. Then the concept of economic advantage, it's the same word, so maybe it is equivalent to the advantage part of the state aid test, but there is a definition offered in clause 3. Advantage will only be conferred if the benefit is provided on terms that are more favorable to the recipient than the terms that might reasonably have been expected to have been available on the market to the enterprise. So that's a pretty clear indicator that the market economy operator principle from state aid law remains alive and well, and I expect we will see guidance that fleshes that out. So our other terms, enterprise, the state aid EU law uses undertaking generally. So in competition law, enterprise is the UK term, undertaking is the EU term, but there's not usually much difference between them, if any. The TCA spoke of economic actors, so there's a third term you can throw into the pot. There is a definition of enterprise in clause 7. So it's a person or a group of persons under common ownership or common control. And that can be relevant because if you have a group and you want to work out, for example, how much aid they've had for the de minimis purposes, you have to look at it on a group basis. And they have to be engaged in an economic activity that entails offering goods or services on a market. So far, so similar to state aid, to the extent that the person or group is engaged in such an activity. So a public authority, for example, a council, when it is offering gym memberships, it's competing with private bodies. So it's going to be probably almost certainly going to be an enterprise in that respect, but that doesn't make it an enterprise in all other respects in relation to education or social care or things like that. So fairly similar. And there's sorry, just stay on that one. There's a carve out there that the activity is an economic effort to the extent that it's carried out for a purpose that is not economic. So again, we'll see what's made of that. And then the Enterprise Act, that's the sort of competition law example that I mentioned, broadly going to be equivalent to the test there, I think. So our next terms, the assistance has to be specific. Is obviously most equivalent to the state aid selectivity test, and clause 4 kind of unpacks that. It says that assistance isn't specific if the distinction in treatment between enterprises is justified by principles inherent to the design of the arrangements. So example, the bill gives as an example in tax cases that those principles would include things like preventing fraud or tax evasion, administrative manageability, avoiding double taxation, progressive nature of income tax, and respecting the ability of taxpayers to pay. And it also says that tax measures are not specific unless an enterprise is treated more advantageously than another in a comparable position under the normal taxation system. Those of you who follow state aid will know about the Apple case and lots of other tax cases in the EU that have caused no end of difficulty in terms of working out when a tax measure qualifies as state aid. So the bill, I think, is trying to avoid arguments down the road in relation to that, although they will undoubtedly arise anyway. And in addition to that, if you look outside tax measures, the question of what principles are inherent to the design of certain arrangements, it may be that your subsidy program has been designed to favor particular players in the market. Does that mean that that's then inherent to the design of the arrangements, and so you can favor them over others? I think it can't mean that. So there are, I think, arguments to be had over when subsidies are and are not specific. And then we have, as I mentioned earlier, the effect, there has to be an effect on competition or investment within the UK, or trade or investment between the UK and another country or territory. So notably different words there. So we talk about trade with other countries, but competition within the UK. The TCA talks about an effect on trade or investment between the parties. So that's UK and EU, no longer between member states, which was the EU test. And the way the EU test had been interpreted by the EU courts, it had become kind of axiomatic that any aid other than the most local things, like a small swimming pool, pretty much any subsidy was likely to be treated as affecting trade between member states. I think under the bill, there is probably going to be more scope, but we'll just need to see what the courts say, but probably more scope to say that subsidy does not affect, certainly, trade or investment between the UK and another country. But this point about competition or investment within the UK is probably going to be where there will be more arguments. Essentially, it's the sort of policy language would be to avoid a subsidy race, where different councils or different devolved administrations are sort of competing with each other to offer subsidies to attract more business to their part of the country than to another. But that effect on competition within the UK, I think, is going to be a key part of what authorities are going to have to grapple with. Okay, so the principles that apply to the grant of subsidies are set out in Schedule 1. Clause 12 says that public authorities have to consider those principles and not give a subsidy unless the authority is of the view that the subsidy is consistent with the principles. That is not the same as you can't give it unless they are consistent. You just have to be of the view. Now, obviously, there will be a reasonableness element there. You won't be able just to turn up in a court and say, well, I concluded that it wasn't. I concluded that it was consistent with principles when it clearly wasn't. But there is potentially a little bit of a margin of appreciation built into that language. So the principles mostly reflect the TCA, public policy objectives, being proportionate, necessary, changing economic behaviour. So actually having a result of making people do things they wouldn't have done otherwise, not compensating for costs the beneficiary would have funded anyway. The objective can't be achieved through other less distorted means. The text that's in purple there is in purple because it should probably be in gold, actually, following our theme. But that is highlighted in that way because that, again, is an addition made in the bill. It doesn't feature in the TCA, but again, making that negative effects on competition or investment within the UK, making that a key part of authorities' consideration. And our final principle there, making positive contributions to achieving the objective that outweigh any negative effects. And again, with a focus on intra-UK competition or investment or international trade or investment. So there's a lot there for authorities to have to consider in designing and granting subsidies. Moving on to the next set of principles, there's a separate set of principles that apply in addition for subsidies given in relation to energy and environment. And those of you who operate in this space will know that the European Commission had produced its own guidelines on state aid in that space. And these principles are, I think, an attempt to generally capture at least the similar themes, if not identical terms. So again, there's a requirement to consider these principles if giving a subsidy in this space and not to give it unless the authority is of the view that it's consistent. So I'm not going to spend time going over each of those because we've got some on this slide, we've got some on the next slide. You will obviously get those, you'll get a copy of the slides. So those of you who are operating in this space, obviously very key for renewables, you'll be able to see what those principles are, but just note that they are there. So our next slide has the rest of those principles. And then the requirements. So these are essentially binding rules that have to be followed in relation to the giving of subsidies. And they include, just summarizing, a prohibition on unlimited guarantees, and that means limit on amount or the duration of the guarantee. No subsidies that are contingent on export performance or on the use of domestic goods or services over imports. No condition that the enterprise relocates existing economic activity. Again, there's that theme there of trying to avoid subsidy races to move businesses, just to move businesses from one part of the UK to the other. And it would also apply internationally though. No subsidies for an ailing or insolvent enterprise. So here we have echoes of the rescue and restructuring aid rules under EU law. So an ailing or insolvent enterprise can only get a subsidy if it is a rescue subsidy offering temporary liquidity support, so loans or loan guarantees, while a restructuring plan is prepared, or a restructuring subsidy where there's a credible and realistic restructuring plan, and the bill also sets out other conditions. So for example, the recipient has to be an SME, or if it's not an SME, there has to be what I've referred to as a bail-in. Essentially, the existing shareholders have to be making a contribution to the restructuring costs. Whether it's rescue or restructuring, the subsidy has to contribute to a public interest objective, such as avoiding job losses or disruption to an important service, or alternatively, if there are exceptional circumstances. So you can see that being relied on in cases like the steel industry issues that we've seen recently. There are special rules for deposit takers and insurance companies, and also special rules for subsidising air carriers. And I know that this regime is of interest to airports and airlines. So just very briefly there, you can see what is said about that. There has to be a public service obligation to run the route, or the authority has to be satisfied that the subsidy will benefit society at large. That presumably means something beyond the solvency of the recipient business. Or the subsidy is for opening a new route to a regional airport that will increase the mobility of citizens and stimulate regional development. So there are particular rules there in relation to air transport. Jamie mentioned earlier, we have the new language, but probably the same concept. So services of public economic interest. The EU term was services of general economic interest. They seem to be the same thing, essentially tasks in the public interest. Think ferries to the Western Isles being the most obvious Scottish example. And the rules are similar, if not identical, to what they were before. The subsidy amount must be limited to what's necessary to deliver the services, but allowing for a reasonable profit. The authority who grants the subsidy has to keep it under regular review and recover any what is called excess, again, that term ripe for dispute. And it must be given transparently, so it must be clear in the contract or whatever the arrangement is, what the service of general economic interest is, what has to be done, what the terms are, and the use of subsidies has to be checked, so essentially an audit requirement at least every 3 years. There are exemptions where the requirements, the transparency obligations, etc., don't apply. Jamie's already mentioned the de minimis threshold. Under the TCA, it's equivalent to 340,000. It's a bit lower under the bill, 315,000, probably to avoid exchange rate issues, putting them out of sync with each other. So what the bill refers to as minimal financial assistance is what EU law would call de minimis, 315,000 over a rolling 3 financial year period. Or if it's for services of public economic interest, that amount goes up to 725,000. That's a cumulative total. In both cases, you still have other procedural requirements, such as having to notify the beneficiary that the subsidy is being received under these exemptions. There are also exemptions for compensation for natural disasters, other exceptional circumstances, responding to national or global economic emergencies, as long as that's a temporary subsidy. In both cases, the UK government has to give notice that such a disaster or emergency exists for those exemptions to be unlocked. Then there's a further grab bag of exemptions, so safeguarding national security, Bank of England, monetary policy measures, subsidies where the Treasury is given a financial stability direction, schemes that exist prior to the bill taking effect. Subsidies granted under those schemes won't need to comply with all of the obligations in the bill. This concept of large cross-border or international cooperation projects is excluded, and so is nuclear energy. So subsidies for nuclear energy do not have to follow the same rules. There is provision in the bill for guidance, so BEIS can issue guidance about the practical application of the regime, including in particular the things set out on the slide there. And if and when that guidance is published, the public authority must have regard to it when giving a subsidy or making a scheme. Hopefully the guidance will be pretty thorough and pretty useful. The guidance that's been produced on the TCA is not necessarily either of those things, but we would hope that certainly prior to the bill taking effect, there will be some pretty detailed guidance issued. Jamie?
Yeah, thanks. So moving on to schemes, these are an interesting new concept under the bill. So a scheme is essentially a sort of umbrella for a type of subsidy. So subsidies that are the same as each other can rely on a single analysis of their compatibility with subsidy control rules and the principles, because they fall under a scheme that has already been analysed against those things. So a scheme can either be made by any public authority to cover subsidies which it will give, or a scheme can be made on a broader basis by the UK government or any of the devolved governments to cover a category of subsidies that can be given by other public authorities. There's also room under the bill, provision under the bill for so-called streamlined schemes, which are to be made by the UK government and laid before Parliament. The intention of these streamlined schemes is really to sort of create a pre-approved route for the lowest risk subsidies. So the types of things that have been analysed by BEIS as falling into a particularly low risk category, they'll create these streamlined schemes, and then everything can proceed under those. Not quite a general block exemption necessarily, but pretty close in certain categories. The requirements that are set out in Chapter 2 do not therefore apply to, so the ones that Charles has just been talking about don't apply to subsidies given under subsidy schemes. They don't have to be subject to their own individual analysis on a grant by grant or loan by loan basis, but the scheme under which they are to be made is prohibited to the extent that subsidies under the scheme would be prohibited if they were being considered independently. So really what that means is that although all the rules and principles don't apply to individual subsidies that are made under a scheme, they do apply to the scheme itself when it's being set up. So it's really a sort of timing and umbrella approach to those things. What a subsidy also means, just the last point on that slide, what a subsidy also means is that what a scheme means is that subsidies made under it aren't then going to be subject to referral to the CMA, even if the scheme is referred. And we'll come back to what referral means in just a moment. So there are some significant new transparency requirements that are imposed under the TCA and therefore under the bill as well. The TCA requires that within 6 months of the grant of a subsidy or 1 year in respect of a tax measure, the granting authority has to publish the details of the subsidy. So its legal basis, its policy objective and purpose, who the recipient is or are, the date of the grant, duration, any time limits attached to it, and what the amount of the subsidy is. Now, happily, the Subsidy Control Bill requires BEIS to create a single publicly accessible database for all UK subsidies and schemes, which lifts essentially the obligation from each individual authority, which it has under the TCA effectively, to find a route to publicising this information required by the TCA itself. So BEIS is essentially saying, report to us and we'll do the central database, we'll do the central recording and reporting of these things. So the information requirement under that provision largely follows what the TCA sets out. Subsidies that are below £500,000 are not required to be recorded if they have been made under a scheme. So if a subsidy of less than that is given but not given under a scheme, then it will have to be on the database. And indeed, if a subsidy is given above that amount, then it has to be included whether or not it's covered by the scheme. But if subsidies are covered by schemes and they're below that threshold, then they don't have to be individually reported and recorded in that database. The same is true of public economic interest assistance that Charles was just talking about, if the value of that is below 14.5 million. And some types of SPEI assistance don't have to be included at all, health related things, for example. Entries then have to stay on the database for a 6-year period, or if it's longer, the duration of the subsidy. So they will be up there for some time. And then there are requirements with regard to individual information requests. So any interested party can request subsidy information by making a request in writing to the authority, the granting authority, and the authority then has to provide all the information relating to the subsidy or scheme within 28 days of the written request. Now, the request has to state that it is only asking for the information for the purposes of deciding whether to challenge the subsidy scheme. And the information that is given by the authority to the requester may only be used for the purpose for which it is requested. So those two things work together. The request has to say we're only asking for this to decide whether we want to challenge it. And then having said that, that is all they're allowed to use it for. So that there is a sort of restriction on the use of information anyway, but on top of that, there are additional requirements, there are additional provisions that allow a public authority to protect, for example, commercially sensitive information in the information that it gives. So what the granting authority has to do is provide such information as would enable or assist the requester to decide whether the scheme or subsidy is in accordance with all of the rules that we've been talking about. And then they can apply whatever restrictions or redactions are necessary to protect commercially sensitive information, for example. Who can request this information? Well, it's not limited to economic actors or to specific interests, so it's not limited to competitors, but that doesn't mean that it's open to anybody to request these things. So one of the things that the bill clarifies is what the meaning of an interested party is. So an interested party is a person whose interests may be affected, a real person, a living person, or a legal person whose interests may be affected by the subsidy or scheme in question, and who may therefore be able to challenge it. So it's essentially, it's potential challengers, but that's much broader than businesses, economic actors, or specific interests. We've made a point there. I'm going to come on to, well, we will come back to this because it's a significant one, is that the transparency process informs the timetable within which a challenge can be brought. So the decision to use or not use the transparency process and to make a request will affect what the timetable is for a potential challenge, but we'll come back to that in a little sec. So CMA referrals, something that Charles mentioned a moment ago. An authority must request a report from the CMA before it gives a subsidy or makes a subsidy scheme that is one of particular interest. Now, what is meant by subsidies or schemes of particular interest is something that the bill says will be defined by BEIS in regulations that will be made later under the bill. But certainly in the rooms that I've been in with BEIS discussing this, what this really seems to be aimed at is two categories of subsidies and schemes: really high value ones, so ones that are of specific interest, particular interest because of the value of them, or ones that are of particular interest because of the sector in which the sectors that they're targeting. So those are the types of things that we probably expect the regulations to define as schemes of particular interest, but there's a lot more detail to be built out in those. So in terms of the timetable, the CMA has 5 working days to confirm that the authority's request for a report is a valid one, and then it has 30 working days to provide that report. Subsidies and schemes that are subject to mandatory referral are prohibited until the report's been issued, and the report having been issued, a cooling off period, which is what the bill calls it, a cooling off period has passed. And that's unless the CMA's time for issuing the report has expired. If the CMA doesn't get around to it, then that's a different matter. But if it does issue the report, then there's a cooling off period. That's 5 working days after the report is issued. But if the report identifies what the bill refers to as serious deficiencies in the proposal, then BEIS can extend the cooling off period for up to 30 working days. And essentially the idea of the cooling off period is to allow the authority to reconsider and to allow for any discussions between public authorities, for example, with regard to whether to proceed. It's also possible to make voluntary referrals to the CMA in the event that a scheme or subsidy does not have to be referred, and BEIS can also refer a subsidy or scheme to the CMA after it has been given, or in the case of a scheme, after it has been made. Now, the Northern Ireland Protocol is still one of the perhaps trickiest parts of the landscape. In effect, the UK now has two state aid regimes that replaced the one that we had before. So we have the TCA regime, the Trade and Cooperation Agreement regime that I set out before in Great Britain, and the Subsidy Control Bill will take over from that. And in Northern Ireland, for goods and electricity, the Northern Ireland Protocol under the withdrawal agreement applies and will continue to apply, but the Subsidy Control Bill will apply to everything else. So Article 10 of the protocol applies EU state aid law, so the one we are all used to and know and love, to any act of UK public authorities, any public authority in the UK, anywhere in the UK, which affects trade between Northern Ireland and the EU in goods or electricity. Now, what does that mean, which affects trade? The EU's view that it has given is that it's the same as the old state aid similar test, which is that it's liable to affect trade, whereas the view that has been given by BEIS, that has been given by the UK government, is that there has to be a direct, genuine link between the subsidy and companies within Northern Ireland. So how to tie those two different views together? Well, the European Court of Justice has final jurisdiction under the Northern Ireland Protocol and the withdrawal agreement to decide on what that means. But there is a more complex question of whether the UK public authorities that are giving subsidies that might fall under the EU's definition, but not under the UK definition of what this means, whether those will notify, whether BEIS will notify the European Commission or not. And also, how will UK courts, and in particular GB courts, handle challenges that are brought under the Northern Ireland Protocol? We can't yet say how these things are going to work out in practice, but there is that complexity there. So just to turn to the bill's effect on Northern Ireland, it does extend to Northern Ireland, but it does not apply, the requirements set out in the bill do not apply to withdrawal agreement subsidies and schemes, including a subsidy given or a subsidy scheme made in accordance with Article 10 of the Northern Ireland Protocol. So if a subsidy falls under the protocol and it is made in accordance with the protocol, then it is done under the protocol. It's not done under what will be the Subsidy Control Act. Additionally, the Subsidy Control Bill remains subject to the protocol, which the EU Withdrawal Act, Section 7A, gives effectively supremacy over other legislation, but that's subject to a clause in a section of the EU Withdrawal Act, Section 8C, which allows the UK government, and this was very controversial at the time, allows the UK government to take certain steps with regard to the protocol. So you'll all have seen in the newspaper headlines and everywhere else that this is something that is subject to some ongoing negotiations and discussions. And so there is an element of watch this space to find out what happens here. But at the moment, that's what it's looking like it's going to be. So a few examples on the next slide just to illustrate how the protocol might work as it currently stands. So if the Northern Ireland Executive gives money to Northern Ireland companies that produce goods for export, or if the UK government, the one to the right of that, if the UK government subsidises wind farm developments in Northern Ireland, then both of those look pretty clearly to have a direct impact on trade in goods or electricity between Northern Ireland and the EU, and so would be subject to the protocol, subject to state aid law. But what if, for example, going down to the bottom left there, Dumfries and Galloway Council gives financial support to the expansion of Cairnryan? Well, that could, for example, lower the price of transporting raw materials from Scotland to Northern Ireland, and then it could make goods that are made in Northern Ireland and sold into the EU cheaper as a result, and that could potentially be within the scope of the protocol. because it's affecting that trade. If the Scottish Government gives grants to turbine manufacturers to build turbines in Leith, and those turbines are then sold to Northern Ireland electricity generators at a lower price than they might otherwise have paid, then they can charge less for the electricity they sell into the EU. And that could be covered by the protocol in the same way. And then the bottom right there, if Scottish Enterprise, for example, it gives a grant to a Northern Irish manufacturer to establish a presence in Scotland, well, could that be covered too? Could the grant help make that company more profitable? Would that potentially allow it to lower the prices of goods it sells from Northern Ireland into the EU? That could be covered. Where exactly this sort of limit of remoteness lies with regards to the Northern Ireland Protocol is something that needs to be worked out over time, but it's certainly something that remains a sort of political hot topic. So we'll see where that goes. Charles.
Thanks, Jamie. So I'm going to cover monitoring and enforcement. Just a quick word to say we've got some good questions in already, but do keep them coming. We are on track to have some time to answer them. So enforcement and remedies, just briefly, what's the position at the moment under the TCA till the bill becomes both an act and comes into force? So we're going back to section 29 of the Future Relationship Act again. Existing domestic law is essentially made subject to the necessity of implementing that law consistently with the TCA. The TCA says that parties have to ensure courts can review compliance, that remedies have to be effective and must include certain remedies, as long as they are available under domestic law. So giving a subsidy that breaches the TCA is unlawful and therefore amenable to judicial review. In England, that doesn't translate into any right to damages, but damages would still be available in Scottish proceedings. And the timings for a challenge under the TCA run from the publication of information. So Jamie's mentioned the sort of transparency requirements in the bill, that they broadly reflect what the TCA required. So once information is published, an aggrieved party has a month to request further information. Then once they get that information, they have another month from receiving that in order to commence their challenge. So it's a little bit like procurement in that a lot of your time frames don't even start to run until you have transparency. So there will, in difficult cases, be a line to be trod between disclosing enough information to actually start the clock running on anybody challenging you, so you don't just have an eternal risk, and providing too much information that actually triggers a challenge. So that'll be something to be navigated. And as you'll see on the next slide, that translates into the bill itself. So interestingly, it's the Competition Appeal Tribunal that's been given jurisdiction to hear these cases. In terms of timings, challenge has to be commenced. So again, the party can make a pre-action information request. That's the request that Jamie outlined earlier. If a party makes that within a month of the subsidy appearing on the BEIS database, then like under the TCA, once they get the response to that request, they have a further month from receipt of that response to challenge in the CAT. If the subsidy is exempt from being entered in the BEIS database, then it's a month from when the party first knew or ought to have known of the subsidy decision. So again, there's a real sort of uncertainty there, and authorities might take the view that even if they don't have to publish it on the BEIS database, they should nevertheless do something to publicize its existence so that the clock on that risk actually starts to run. If a post-award referral is made to the CMA, then your challenge has to be commenced within a month of the CMA's report being published. Otherwise, if there's no such report and no information request was made, then it's just within a month of the subsidy being entered on the BEIS database. A challenger will almost certainly request information in order to get the benefit of that longer time frame, and indeed to get the information that they require. Although there are provisions in the CAT rules that are being introduced for this, for the CAT to dismiss an action based on undue delay. So actually, if a party has everything they need to just go within that first month, then the CAT may frown upon using an information request just purely to string out the process. The CAT, as in all things, can sit as a Scottish tribunal, in which case it applies Scots law, Scots rules of evidence and procedure, and appeals go to the inner house. Wherever it's sitting, it will adopt judicial review standards and remedies. So essentially that means you're going to be looking at state aid cases as a species of ultra vires cases. And it can order recovery. So as under EU law, if subsidies are unlawfully granted, then the CAT can order the recovery of that, including the payment of interest. So we have various questions about how is the CAT going to approach cases. The principles themselves are open to interpretation. What margin of discretionary judgment will they give to granting authorities? Will they actually pay close scrutiny to decision-making processes and evidence? Will they take almost a sort of a merits review of whether a subsidy can be granted, whether it's compliant with the principles, or will it be a bit more hands-off, and will they just ask themselves the question, was the authority entitled to come to the view that it was consistent with the principles? And then you've got all sorts of terms within those that can be and probably will need to be defined. What does necessary mean? What does proportionate mean? What are normal circumstances? As I just mentioned, how long is an undue delay in what contexts? So lots of things for the CAT still to look at there. So just to sum up, if you are in the public sector, then the key issues for you under the new regime, and obviously to some extent these already exist under the TCA, there are significant transparency requirements, and your challenge risks will persist until information is published. I think public authorities need to be making sure that this is built into their information control, information management functions, including will staff recognise requests for subsidy information. So if one of the requests that Jamie outlined comes in, you have 28 days to respond to that, essentially the same as the 20 working days under FOI. You'll have your FOI processes in place so people will recognise an FOI request. A request for subsidy information probably qualifies as an FOI request, but will it make it through the information team to the people who actually deal with the subsidy control issues? So these are sort of internal management tasks that will need to be considered. By comparison to state aid, the bill has much more in it than the law did in the EU, which was essentially just an article in the TFEU, with everything then filled out by a combination of case law and commission guidelines and notices. So we have much more in the bill itself, which is better, I think, but we have much less guidance. So it's sort of giving with one hand and taking away with the other. Obviously, we'll see what comes out by way of guidance, and that may prove pretty important. There is going to have to be much more self-assessment of lawfulness, because there's no longer a commission to notify your aid to and have it cleared, and simply by the act of it being cleared, it is considered to be lawful. So there's potentially more flexibility, but with a trade-off against certainty, so not as much certainty. The CMA's role is not to approve the grants of subsidies per se, so it's not like the Commission in that respect. But if something does go to the CMA, and the CMA gives it a clean bill of health, then that might give a considerable degree of comfort, if only because it would be a relatively brave challenger who would take you to the CAT saying, I know the CMA gave this a clean bill of health, but I disagree. In terms of applying your existing EU state aid expertise, is that now all just sort of redundant? I don't think it is. I think what you can probably regard those as would be a floor. So I think if there's any ambiguity under the bill or the resulting guidance, you can probably take the view as a starting presumption, but a rebuttable one, that if what you're proposing to do would have been okay under the state aid rules, it's probably still okay under the bill, but obviously don't quote me on that in all circumstances. Then for the private sector, the key issues that we see on the next slide, the risks are what they were before for recipients. So clawback of unlawful subsidy remains a real possibility, and ultimately it's the recipient that bears the real brunt of that. If there's less certainty for the granting authority, then there's less comfort for the recipient. So you can no longer comfort yourself by saying the Commission's approved this, in which case, you know, you're home and hosed, you don't really have a risk to be managed. So it's possible that in terms of getting the additional comfort from the CMA, recipients might consider getting a clean bill of health from the CMA a condition of accepting a grant. Obviously, there are only so many circumstances in which that would be worthwhile, but for a big project, for big amounts, a CMA report may be mandatory anyway, but if it's below the thresholds, once those are set, you may still make it a condition. And similarly with third-party funders, if you're financing a project that if the subsidy element was removed, it would all fall over, then again, you may want to look at what you can do to get that extra comfort. And there's also uncertainty in the short to medium term, particularly over what will have an effect on competition or trade within the UK. And if you're not a recipient of a subsidy, the transparency rights are there to allow for challenges, but you are subject to those new short procurement style time limits. If you are looking at something, you need to consider, does the Northern Ireland Protocol apply? If so, you could go to the Commission to enforce it or take action in the UK courts based on the state aid principles that are well established and understood. If the protocol doesn't apply, then you're looking at judicial review with, at least in the short term, more uncertainty about processes, timings, substance. Although if you think the breach contravenes the TCA as well as the bill, you may still be able to cause some mischief and bring the EU in on your side against the UK, but obviously we're then straying into high politics territory. Okay, so that's our summary of the key issues. Got some questions. First question is slightly devilish one. So the economic activity test is interesting in the context of local authorities operating heat networks and selling heat to third parties. I'd have thought that counted as an economic activity for the purpose of subsidy control, as there's a market for the provision of heat, even if there's only one heat network in the area. Any thoughts on this? Jamie, you got any immediate thoughts?
Yeah, I think given that the economic activity test that the bill kind of sets out it's independent of the existence or non-existence of competition for a particular activity. So I don't think that it's prejudicial necessarily that there are not other people that are competing with something for it to be an economic activity for the purposes of subsidy control. And my gut is that heat networks and selling heat to third parties, because it is something that is done on a market, even if that market is not necessarily, even if it's a lot of different markets in practice, I would think that would apply.
Yeah, I would agree with that. I mean, I think obviously there with the energy and environment principles and things like that, there may well be lots of ways for that subsidy to be lawful. But I wouldn't attempt to escape the rules based on arguing that it's not economic activity, I think would be the way to look at it. Question, does cross-border, so this is in relation to the cross-border and international large projects, does that refer to within UK borders as well as international? That is a good question. I had the same thought when I was looking at it. I think the fact that they are two separate terms suggests that it does.
There's a requirement that there is a benefit that is not just a benefit within the UK. Mm-hmm. So the implication of that would certainly be, I would think that that if part of the benefit has to be felt outside the UK, then it wouldn't simply be something that could be across internal borders.
Yeah. So I've seen it used in both contexts in other pieces of legislation. Remember that the bill is at its early stages. I imagine that's the sort of thing that will get picked up at some point, and there'll be an amendment to define what that means. Just related to that question about timings and when the new regime might be coming in. So the bill was introduced at the end of June, but obviously Parliament then went into its summer recess. It's only at its committee stage. It's had its second reading in the Commons, but that's it. It's going through committee stage at the moment. So there's still a lot of parliamentary procedure to go through on this. It doesn't look like it's being particularly expedited, although obviously there is a desire to get it done sooner rather than later. I'd be surprised if it gets royal assent before sort of spring, so Q2 of next year. So if I had to guess, and it was purely speculation, I think there's you're probably looking at the middle of next year as probably the earliest before the act, the bill will not only become an act, but will come into force. And just by comparison, National Security and Investment Bill, which is not dissimilar in terms of introducing a sort of a regulatory regime that where there are pressing reasons to get it done quickly, but not necessarily rushing it. That's going to be 12, 13 months from its introduction to coming into effect. So I think probably looking at something similar here. Jamie, also a question about the CMA's involvement. How sort of geared up are they for that?
I think they're perhaps less geared up than they might have been. So those that have been following this from the start will know that the CMA was originally sort of intended to have a role with regard to subsidy control, to how that was done. And then when the initial consultations started, there was a lot of talk of square brackets, independent body, whoever that might be. And a lot of humming and hawing about that went on before when the Subsidy Control Bill finally came. It turns out, lo and behold, that the independent body is the CMA after all. So there's an extent to which the CMA may have lost some time preparing for all this. There is a state aid unit within the CMA. It is something that has been ramping up and getting ready, but obviously there will be an extent to which they have had to spend time waiting the way that we've all had to wait to see what was in the bill. And now that we have the bill, we'll be responding to that by ramping up some more. So there will have to inevitably be a period of sort of finding their feet, if nothing else. But the preparations have been a wee bit on and off, I would think. So so it might take some time.
And then I think we'll just take one more question. So can the new bill support agriculture, or are there exemptions? So agriculture is obviously a very tricky area in relation to subsidy control. It has its own rules within the EU regime. It's subject to separate agreements internationally in terms of WTO arrangements and that sort of thing. My understanding is that support given in relation to agriculture will be dealt with under the Agriculture Act 2020 and regulations made under that. I'm not sure the relationship between that and the Subsidy Control Bill is necessarily clear on the face of the Subsidy Control Bill, but that would certainly be my assumption, that agricultural support will be dealt with separately from the bill. There's no distinct provision made within the bill for agriculture, and I think if the bill was intended to cover agriculture, there would have to be a separate section, separate set of provisions for it. So I think that relationship probably needs to be spelled out a bit more clearly. But no, I would look elsewhere in relation to agricultural subsidies.
Can I just pick up quite quickly on a couple of questions, small ones that were there? One of them was, is the BEIS database open for reporting of grants that are being made now, pending the bill coming in? The answer is that the mandatory database obviously isn't, but BEIS has started a database, did start a database fairly early on after the TCA came in. So there is a route for that reporting. It's pretty sparse at the moment. So I'm not sure how many people know about it and how much BEIS is engaged on it, but yes, there is a route to publicising these things through BEIS at the moment, and complying with obligations that way.
Yeah, and I'll just add in relation to that, Jamie. So the obligation to report on there isn't as expressed as it is under the bill, but if subsidy hasn't been reported, then it will remain challengeable under the TCA until it is, and then the period for challenge is passed.
Yeah, and then another question was, is there a definition around ailing or insolvent organisation? Does it follow undertaking in difficulty? The answer to that is that there's a very, very elaborate list of definitions of these things. And I just wanted to mention that that it looks similar, but we'll wait and see.
Yeah, And again, just go back to that point, very early stages for the bill. There's
Yeah.
lots of things that could and probably will be done to it by the time it becomes an act. Okay, if we didn't get to your question, or there's something you didn't want to put in the chat but want to ask us, our contact details are there. Do get in touch. I'm sure we'll be working with at least some of you in the future on these issues. But in the meantime, that's quite enough from us for today. So thank you for your time, and we'll see you next time. Bye.
Thank you.